Okay, let's talk about the proposal. Disclosure. We are in Reg D, if it's audible accredited investors, industry practice is certainly to provide a PPM, but there's no requirement under Regulation D to provide a PPM. But under our proposal, a document would have to be supplied to investors that would disclose whether the broker who's raising money for the issuer is affiliated with the issuer and the nature of the affiliation. And for affiliation, we said affiliate is an entity that's controlled by or under common control with the issuer, which is, and then we reference the rule for public offerings, the affiliate definition, which is 10% of voting profits or losses or the power to direct the management of an entity. We also, within that definition, is 10% of an entity's subordinated debt. One of the comments that has come in objects to the 10% subordinated debt. They say you hold 10% of an issuer's subordinated debt, you don't control them, which may or may not be true. But with regard to this disclosure of the affiliation, we all know that the SEC just did a report back to Congress on fiduciary duties, and I think you've heard that Rick Ketchum, who's the CEO of FINRA, is on record as saying FINRA supports fiduciary duties for brokers. Now, the devil is truly in the details, because proprietary trading, the way it works on the Advisors Act, wouldn't work for brokers. But I think it's not clear. I've read, and many of you have too, I'm sure, the SEC's report on fiduciary duties, and so it's not clear exactly how that would work. I think today, for example, I think under common law of agency, you execute a transaction, you actually are working as, you do have a fiduciary duty. It's just that the duty ends once the transaction is executed at the end of that. But one thing I think, I'm sure, if a fiduciary duty is imposed by the SEC on the broker-dealer community, is there's going to be more requirements to disclose conflicts of interest. So I think this part, the disclosure part, is something that everybody in the room is going to have to do with PPMs, whether this rule requires it or not. I think that's going to come out. We're going to need a lot more disclosure of conflicts. The other thing that would require to be disclosed is the use of proceeds. And the use of proceeds is something, once again, that we requested comment on. And what we said is that 85% of the capital raised has to be used for the business purpose that's described in the PPM. Now, we've already gotten some comments back that we're looking very closely at. And those comments say, 85% is okay for certain size deals, but it's too much for smaller deals. And one of the comments that came in said for deals under 15 million, it should be 75%. There's no magic to 85%. 85% has is a number that's used in some other public rules, DPPs and REITs. The state imposed it for unlisted REITs, as many of you know, that the 85-15. But we weren't proposing the 85 because it's some magic number. Instead, what we think is that, I really think so too, an investment becomes more risky the less of the money that you invest is being used to generate a return on your investment. And so, we're listening, but if it's much less than 85% is being used to generate a return on your investment, that becomes a pretty risky investment. On the other hand, we've talked to some people and tried to make clear, well, what does that mean, generate a return on your investment? We had a fellow came in, he's got a company that buys real estate and holds it for future development, but it generates no revenues. And they have a 1% management fee a year on the real estate until it is sold. And they were worried about, well, is that use of proceeds that they couldn't, that 1% would be not considered each year to be out of the 85%. Well, no. If you're managing the property, that is a use of proceeds that is being used to generate a return on investment. We really mean that it's not commissions or other fees that are simply going towards raising the money. We didn't cap or propose to cap the money that can be spent raising the money. So we didn't say there's a 15% cap. So, for example, if a broker's being paid from some other source and proceeds to raise the capital, or the broker's being paid with warrants or some kind of securities that aren't coming out of the capital, that would be consistent with the proposal. And with regard to smaller offerings, we're going to think long and hard about that and listen to the comments, because I think one thing we did last year is publish a notice called 1022, where we talked about a broker's due diligence obligations with regard to private placements. And certainly, we don't want people skimping on due diligence. Due diligence is very important. That's why we published that notice to put out industry best practices. So it may be, I've gotten feedback that on some smaller offerings, there's fixed costs that go along with due diligence that should make us think we should tier or somehow adjust that 85% number. And we'll consider that as well. The other thing that the proposal requires is that the PPM would be filed with FINRA, filed with my department, one of my departments, the corporate financing department. And once again, we try to do this in a way that is, I don't see myself that the disclosure requirements or that the process of most of the proceeds be used to generate a return on investment as disclosed is burdensome, and I don't know why it's expensive. But certainly a filing requirement sounds like it could be burdensome and expensive. So I've tried to make it absolutely as simple as possible. We're going to have brokers, they don't have to hire lawyers. Brokers would be able to file with us the PPM through the firm gateway. And the PPM would come in, and I'm working with, I got a big new budget. I'm working with our technology people. We will be able to use some different kind of sorting and artificial intelligence technologies to identify PPMs that may have issues. And then we would be able to review those both as an analyst. And also in the firm gateway, the examiners would have, in the queue, be easily able to see, which PPMs are in there. And that said, it would only have to be filed once. If there's a group of firms that are selling a particular private placement, only one would have to file that PPM, so it's not multiple. We're trying to keep it as simple as possible. There has been some confusion about, although in the notice, if you've read it, I've said over and over and over, they said file the PPM prior to first offering it to an investor. But people are concerned, I'm getting feedback, that we're somehow going to require them to wait like the SEC would, or like we do for public offerings, frankly, before selling can take place. That's not true. In fact, you can't wait, because we anticipate we're going to get 4,000 to 5,000 filings in a year, judging by the amount that come, judging by a survey we did, a sampling we did of Form Ds. So it would be impossible for us to do that, and we're not going to do that. So one thing we're thinking about is saying, well, maybe file the PPMs within 10 days of first use. It doesn't matter so much. The timing doesn't matter. The reason why we said file it before it's used is, in now many years as experience as a regulator, if people have to do a bunch of things before the selling takes place, they do it. If it comes afterwards, we may get more non-compliance. But the date is really for that purpose, to get people to focus on it at a time when it's necessary. So maybe we'll go to 10 days of first use so that nobody's confused about that.